Okay. All right. Thanks everybody again for being here and for giving me a second to just, do my spiel about the Pretrial Fairness Act, really what it's all about and what's been going on with it recently. Let me see if I can share or not share my screen, but put this in slideshow mode. All right. Can everyone see my screen okay?
Yes.
Good. Great. All right. So my name is Kareem Butler. I am a pretrial justice fellow with the Chicago Appleseed Center for Fair Courts. And the Center for Fair Courts, or the Chicago Appleseed Center for Fair Courts, is a legal and legislative advocacy organization. We work across the legal system to really fight racism, to fight the equity and the injustices that we see across various facets of our legal system. So we have staff that address criminal justice issues, access to justice issues, civil liberties and policing, immigration reform, family court as well. And one of the issues that we've been working on really heavily over the past few years has been pretrial reform. And if you're not really familiar with the Pretrial Fairness Act, you might be a little more familiar with the term the Safety Act. The Pretrial Fairness Act is a subset. It's a portion of the Safety Act that just handles pretrial reforms across the state. So that's really going to be the crux of the conversation today. And I'm going to talk about, again, kind of what it is and how it's changing our pretrial systems across Illinois. So here's just a little brief overview for what we're going to discuss. Again, I just wanted to illustrate, a little bit about who we are, not only as an organization, but Chicago Appleseed is a part of a broader coalition. So I'll talk a little about that. I will highlight some of the impacts of money bond and the pretrial system and pretrial detention. I want to talk about how money bond works. Again, what the Pretrial Fairness Act really does in its current form as passed. How pretrial freedom makes our communities safer, and really how you can get involved as community members who are concerned and interested in this issue. And then at the end, we'll have some time for some questions and answers and a little bit of discussion maybe. So yeah. So the Illinois Network for Pretrial Justice is a consortium of organizations, and we are a member organization of this larger coalition. It works to connect organizations to reduce pretrial incarceration across the state, and to more broadly end mass incarceration, and to address the root causes of social and economic, racial inequity in our criminal legal system. Our network is also grounded in the principles of bond reform in Illinois, which I'll dive into a little bit more. So just really highlighting the effects of money bond in Illinois. Every year, more than 250,000 people are incarcerated in the 91 county jails in Illinois. 90% of them are being jailed pre-trial, which is a lot higher than the national average, which is about 67%. And the majority of these people are incarcerated purely because they can't afford to pay a money bond. So money bonds are, used nationwide, as I just alluded to, and really sort of the passage of the Pretrial Fairness Act, the genesis of the work that led to that is really rooted in the fact that the use of money bond criminalizes poverty, in particular criminalizes Black and Brown communities. So I'm going to dive into a little bit of that, but that's just some background as to why it's so important that we really abolish money bond, which is one of the features of the bill. So this is just a little visual representation of really how the current system works. So, a lot of people are pretty unfamiliar with the bond system if they haven't had direct experience, if they haven't had a loved one or a family member who might have matriculated through the criminal justice system. But this is just a visual representation of what happens from the point of arrest into either jail or release from pretrial detention. So after you're arrested, charged, and then booked, you'll be taken to a police precinct, and usually, and it can vary depending on the county that you're in, But usually after about anywhere between 24 to 48 hours, you have a bond hearing. At that hearing, a judge is going to make one of several determinations. They're either going to release you on a non-financial form of release, or they're going to expect you to pay a money bond, or they can outright deny your bond. So that's what really this flow chart represents. In Cook County, if you're going to be released on a non-financial form of release, then the judge might say, I'm releasing you on 10,000 I. If you get an I bond, that just means that you're free to go home pending trial. You're not expected to pay that money. That theoretically, the court, if you don't show up for a future court date, they can levy those charges against you. So if they say, I'm releasing you on a $10,000 I bond, theoretically, if you weren't to show up to your subsequent court date, they can levy a charge of like 10% of that, $1,000, but that almost never happens. In a lot of other cases, as I mentioned, people are stuck in jail because they can't afford their bond. You can either be stuck in jail because you can't afford your bond, in which case you'll be incarcerated up until your trial or future court date. Or if you have the financial means, you'll pay your bond and you'll be financially released. Judges right now also do have the ability to just outright deny someone bond depending on the charges or the case circumstances. That can be done arbitrarily as well. There's a lot of judges wield a lot of power to use their discretion. Okay. So pretrial incarceration is really devastating. And even for just a day, has a really massive impact on people's lives. Even after just 24 hours, people are 20% more likely to be rearrested while their cases are pending, spend 72 hours in jail, and people are 40% more likely to be rearrested. And this is just essentially because jail is really destabilizing for people's lives. After a month in jail, people can lose access to crucial benefits that they were receiving, creating gaps in coverage when they end up inevitably getting out. And the first few days in jail are actually really, really dangerous, especially for particular vulnerable groups, individuals with certain mental health conditions, even individuals with specific substance use disorders. For example, folks who have really serious opioid use disorders. There is no medication-assisted treatment in jails in Illinois or in prisons. And so for a lot of individuals, who have very serious substance use disorders, for opioids, this can be a really dangerous situation, even being in jail for just a few days. And individuals who are particularly vulnerable in that sense can actually die in jail, and that has happened. Pretrial incarceration also creates convictions. This is something that isn't spoken about a lot, but for individuals who are incarcerated pretrial, there's a 4 times greater likelihood of being sentenced to jail, and there's a 3 times greater likelihood of being sentenced to prison. Pretrial incarceration also results in longer incarceration itself. So individuals who are detained pretrial are likely to have 3 times longer jail sentences and are likely to have prison sentences that are twice as long as individuals who are released pretrial, either because they paid their money bond or because they were released on an I bond, as an example. And then finally, pretrial incarceration also increases the likelihood of future rearrest during the pretrial period and for years afterwards. The length of incarceration is going to increase, studies have shown, depending upon how long you've been in pretrial detention. So if the longer you spend behind bars awaiting trial, typically the longer your incarceration in prison is likely to be. And really, before I move on, I want to play this video that I think also kind of helps speak to how individuals who move through the system have been affected by money bond in Illinois. And let's see if it plays. Can everyone see this?
I was incarcerated pre-trial for 2 months.
2 months, 3 months, 1.5 years, simply because I couldn't afford to pay $1,500.
Yeah, the sound stopped. Or is it just me?
The sound stop?
The sound stopped almost immediately. So we heard the first couple of seconds.
Okay, well, you know what? I'll go ahead and share the link to the video after.
Mhm.
It's a really powerful video, and the individuals who are in the video were actually, supporters that shaped the Pretrial Fairness Act as it currently exists. And their stories, I think, are important to hear. So I'll make sure after presentation's over to send that link around. But I think their stories are just really important to lift up. So I just wanted to add that really quickly, but let me return to the slide deck. Where is it? Sorry, 1 second. Okay. Sorry about that. 1 sec. Wi-Fi is slow. There we go. All right. Can anyone see my screen?
No.
No.
Okay. 1 second, sorry. How about now?
Trying to come up.
Got it?
Just say we have started. There we go.
There we are.
Yeah.
All good?
Yes.
Okay. All right, thank you. Sorry about that, technical difficulties. So, as before I really dive further in to talk about the different aspects of the legislation that I think are really important to highlight, I just want to provide you guys with a little bit of context about how the bill came to fruition. So, as advocates, we began working with legislative partners to draft legislation to end money bond, actually all the way back in 2017, 2018. And the process to try to pass the law was actually started in 2019. The uprisings following the murders of George Floyd and Breonna Taylor really lent a lot more urgency to the efforts of reform. And I think that's because this issue of pretrial incarceration and really mass incarceration is obviously so heavily racialized. Our jails in Illinois are mostly filled with Black and brown people, despite the fact that Illinois is predominantly white. Actually, Cook County is a great example, really anywhere in the state's a great example. But in Cook County, I was giving a talk the other day where, I shared this statistic just kind of looking at the jail data that's available for the Cook County Sheriff's Office, and of the individuals who are currently in custody, and I think it's about 5,600 something, over 74% of them are Black. And this is in a county where, 23% of the entire population is Black. And so I think it's important to really drive home how racialized this issue is. And that's not a pattern that's specific to Cook County alone. That's a trend we can see across the state. But just going back to the protests and the uprisings that really occurred throughout the summer of 2020, I think they really delivered a lot of momentum to help pass the Pretrial Fairness Act, which again passed as a portion of the Safety Act. It passed in January of 2021, and the provisions involving money bond that I'm going to speak about were given a delayed effective date so that the system was given time to really prepare and make sure that these reforms actually work. So that's what happened to make this possible over the last few years. And now I'm just going to get into some of the principles that really undergird the law itself that helped form these specific features of the legislation. So the bill was shaped by a set of principles that came from different reform advocates, that came from impacted people. And to properly explain how the bill works, I'm just going to walk through those principles and talk about how they'll be implemented once the law goes into effect in January of 2023. So the first principle is pretty straightforward, and it insists that money should never be a determining factor in whether someone's free pretrial. What the Pretrial Fairness Act does to realize this principle is to end the use of all money bonds across the state. So some folks have asked if this only pertains to specific charges or individuals with certain case circumstances, like folks with misdemeanors or petty offenses. But the answer is no. This ends the use of money bond for all charges, regardless of the charge. The second principle, and this is probably the most important one that I'm going to spend the most time talking about, is that release from jail before trial should be the norm, and that detention should be the carefully limited exception. And that language might sound a little bit technical, but it comes from a U.S. Supreme Court case called U.S. v. Salerno, which happened back in the 80s and basically said that most people should be released pre-trial, and that we should only be using jail in a very limited set of circumstances. Unfortunately, because of the way our money bond system works, we use jail for all sorts of cases pretty much arbitrarily. I've seen individuals go through bond court and get money bonds as high as $50,000 for retail theft. And there are a lot of different individuals who might come through with, they might come through the same courtroom with a much longer series of priors who, for whatever reason, might get a slightly lower bond than that. So there's not really a rhyme or reason as to why or how money bonds will be doled out. And so when the PFA gets rid of money bond, it replaces it with a system where the purpose of the system is to reduce the number of people who are in jail. And the first way the law accomplishes this is through creating a process for the release of most everyday low-level charges that the majority of people who get arrested and come into the courtroom are charged with. So if these individuals are arrested and brought to the station, they will then have what's referred to internally as a conditions hearing, where they should be released. Judges can impose conditions on their pretrial release to make sure that they come back to court and that the community remains safe, but jail isn't on the table for most charges. There are charges for which jail is on the table, and individuals can be jailed if, for example, most serious felonies can be jailed if the state is alleging that someone is either going to flee the jurisdiction, or for safety reasons, if the state's alleging that detention is necessary to ensure the safety of another person. But I just want to add that, that doesn't mean that everyone who's facing those more serious felony offenses will be jailed, but there's a process that judges can follow if they want to use jail in those circumstances, and I'll get to that in a moment. On top of that, police are under the PFA required to issue citations for a process referred to as ticket and release, similar to traffic tickets for most ordinance violations, petty offenses, and similarly non-serious charges. So running a red light, jaywalking, drinking alcohol in the public way, unless there's a specific risk posed to other people, or unless the person poses an obvious threat to themselves, ticketing and release should be the norm once the law is implemented in January of 2023. And this is really, again, just done to decrease the number of people who are even being brought into jail for 24 hours. Because again, as I mentioned, even being brought into jail or police custody for a short amount of time can be really damaging for a lot of people. So in general, what this does is raise the standard necessary that the state has to meet, the state or the prosecution, in other words, has to meet to incarcerate someone before trial. A problem with our current system is that a lot of people just spend time in jail for very minor charges. So many of the offenses that I just listed, traffic violations, petty offenses, jaywalking even, individuals can and do spend time in jail throughout various counties in Illinois on those charges. And this can be massively disruptive to people's lives. So it's critical just to make sure that we, diminish that window of time that people are spending in jail, because it can be so destabilizing. I think it's just also important to drive home that, being in jail even for a limited amount of time can mean lost jobs, can mean lost custody of someone's kids, can mean, obviously very devastating health effects for the people who are experiencing jail themselves. But I just think it's important to drive home, what that could actually look like. It could be lost housing as well. So I just think it's important for people to understand that. Under the Pretrial Fairness Act, the court has to be able to prove three things. And I'm going to get to that in a second, but in cases where jail is available, the Pretrial Fairness Act doesn't necessarily say that the individuals facing those charges is to be put in jail. So people still have the presumption of innocence under the Pretrial Fairness Act, and many of them are innocent, and we want to make sure that they have due process before their freedom is taken away. So again, the court has to be able to prove three things before incarcerating someone pretrial. They have to prove that there's probable cause that the person committed a serious felony offense or qualifying offense under the PFA. They have to prove that the accused person represents a specific, real and present threat to the safety of another person or persons, or represents a high likelihood of willful flight. That's or, not and. This also might be the most important one, but the judge has to find that no other conditions other than jail will protect the public from a specific real and present threat to another person or from willfully fleeing the jurisdiction. So basically what that means is, if a judge can think of any other way that a person can be released safely, then they have to be released under the PFA. Only when jail is the only option on the table should it be used. And I apologize also for it getting extremely dark in here. Having some issues with some lighting in this room at the moment, so forgive me for that. So this is, again, another visual representation of really what happens from the point of either arrest or from the point of contact with law enforcement under the PFA. And it's, you saw in the previous map what happens under the current system. You immediately go to bond court. Now, under the Pretrial Fairness Act, for lower level charges, people can be cited and released when they're stopped on the street by law enforcement. They can also be cited and released from the police station if they're charged with certain crimes that might, from the point of view of law enforcement, require that they are at least arrested, fingerprinted, brought into the police station, and they can be released, ticketed and released from there for certain other lower level crimes. Everyone charged with a more serious crime goes to a conditions hearing, which is where a judge will determine what conditions will be placed on you when you're released. If the prosecutor wants to jail someone, there's a different process that they have to follow than they do under the current system. They would have to file a petition, a motion for detention, basically, at that hearing. And then a detention hearing, if that motion is granted, will be held, where the judge has to make the determination that I basically just explained. The reason this is just a helpful visual, is because it just illustrates how under the PFA, there are fewer ways to be jailed than there are to be incarcerated pre-trial, and that's exactly what we're trying to look for. The third principle is that accused people need to be viewed holistically, and that risk assessments, which I'll explain in a moment, aren't used as substitutes for individualized decision-making. If you guys can just give me a second, I'm going to try to provide a little bit of lighting in here because it's starting to freak me out. We have power. So we want every single case to be considered individually. We want people's family dynamics taken into account. We want their employment situations taken into consideration, and anything and everything that might be able to show that this person has been and can be a productive member of society as they await trial, or as they await a future court date. We don't want people to be seen as just the thing that they're charged with, which is basically what happens under the current pretrial system. And one of the ways that this happens is through the use of risk assessments. So risk assessments, in an essence, basically rely on various formulas that take people's criminal history, plug them into a formula that essentially says someone is a 4 out of 6 on the scale of how much of a risk someone has of being rearrested pre-trial. Jesus, what is going on? Sorry, excuse me. There we go. Those risk assessments can really bake in a ton of racial bias because, you know, if your scoring system is relying on how many times someone has been arrested in their criminal history, Black and brown communities tend to be and are often over-policed. And Black and brown individuals tend to be arrested because of the over-policing for very small infractions and for the same infractions that white individuals are often given a pass for. So risk assessments will have a diminished role in deciding whether someone is released pre-trial. Defense attorneys will also be able to challenge risk assessment criteria, which they are currently unable to do. Under the PFA, we'll be treating missed court appearances in a more humane and reasonable way. So under the current system, if you were to miss court, it's almost always the case that a judge will forcibly bring you in, issuing an arrest warrant. And as I mentioned before, people, you know, are rarely is it the case that people are intentionally trying not to appear in court. Usually, the most common reasons would include a lack of transportation, and people have lives too. A lot of times, it's as simple as people forgetting that they had a court date coming up. So we don't feel like it's right for people to automatically be detained all the way up until trial, which can be a significant amount of time. There are people sitting in Cook County Jail who've been there for as long as 8 years, waiting trial. We want to make sure that, given the fact that the rarest reason people are missing court is because they're intentionally trying to flee prosecution, we want to make sure that failure to appear isn't being used as a basis to really detain someone in a risk assessment score. And then the fourth principle is really that courts should help accused people attend court hearings and restrain their freedom as little as possible while they are legally innocent and awaiting trial. So when people are released, judges can definitely put conditions on folks like electronic monitoring, but the law looks for less intrusive means of helping someone make their court appearances using things like court reminders. So as I mentioned before, right now, the justice system is very punitive and can be extreme. I'm sorry, I'm getting a little bit of feedback, I think. Thank you. The justice system can be really punitive, and rather than issuing things like court reminders, you know, right now, individuals are kind of expected to just remember either their court date or their, you know, sent communications via mail. One of the more proven and effective methods that the court can use and is encouraged to use under the PFA of communication is text message. Checking in with probation officers has not been proven to help. Electronic monitoring does not help. Text messages have actually been proven to work most effectively as a method of communication to get people to come in. And importantly, you know, the PFA also reforms the warrant process. So as I had mentioned before, under the current system, individuals can be arrested and brought forcibly into court. We don't want that to happen for a failure to appear. We want individuals to be given, if anything, a warning to come in before that happens. So judges are now under the PFA encouraged to make use of less intrusive and frankly violent options to bring individuals into court for missing a court date. The Pretrial Fairness Act also reforms electronic monitoring, which I mentioned before. And it's important to really remember that electronic monitoring isn't an alternative to incarceration. It's just an alternative form of incarceration. So the Pretrial Fairness Act doesn't eliminate the use of electronic monitoring, but it does add some important protections for folks who are on EM, electronic monitoring. So under the current system, electronic monitoring restrictions are, you know, massively severe and can cause really serious harm for individuals on it and their loved ones. People on EM are routinely denied the ability to go to work, to care for their loved ones, to go to the grocery store. And those are really basic functions that we believe people need. So this is just a slide that really talks about what some of those basic reforms for electronic monitoring are under the Pretrial Fairness Act. For one, judges must reconsider any order to electronic monitoring every 60 days to look for any means that, you know, might be less punitive, less restrictive of an individual's freedom. Secondly, accused people must be given movement to do essential tasks. They're still monitored during this time. Third, this would also prevent people on electronic monitoring from being charged with felony escape for minor violations by requiring individuals to at least be AWOL for 48 hours before automatically being incarcerated. And then finally, people have to be given under the PFA credit towards their sentences for any amount of time that's spent on electronic monitoring while awaiting trial. So our fifth principle is that people should be treated fairly if they do violate the conditions of their pretrial release. So when someone is released pretrial and they have conditions put on them, they can obviously forget to report to their pretrial services officer, or they might violate the terms of their GPS monitoring. And when that happens, the law really creates a process for determining that what happened wasn't done willfully and that there was some sort of mistake or barrier that might have caused that violation. And the law also disallows the permanent revocation of pretrial release for most violations. So, and just to, you know, remark on that point about, you know, checking to see whether or not that violation happened willfully or whether there was some sort of mistake or barrier that happened. For a lot of people on electronic monitoring, the technology that they use is not perfect. It's very faulty. There have been several lawsuits around the country focused in on the on GPS monitoring or radio frequency monitoring. These are two of the most common forms of technology that are used for individuals who are on EM. And there are a lot of false alerts created by these technology. You know, individuals who are on radio frequency a lot of times have to have their tech plugged in to keep its battery charged. That can be a reason why individuals have false alerts issued if the batteries die in those devices. For GPS monitoring devices, the technology itself relies on cell towers or base stations. In minority communities, for one, base stations are less prolific. There are fewer of them. And so you have a lot of individuals relying on one base station where all of the cell traffic is going. GPS monitoring the fact that they use those cell towers, means that they are prone to having signal interference. And in those situations, you can have false alerts produced as a result. And that does happen very frequently. So we want to make sure that if there's some sort of violation of a condition of pretrial release, as an example, if there's a violation of electronic monitoring, we want to make sure that it was done willfully. And then the last final principle is that pretrial practices should be transparent and accountable. So the law basically just creates a statewide data collection and publication process, because right now we know really, really little about what's going on in our courts and how many people are moving through them, what their charges are, what's happening after arrest. So the Pretrial Fairness Act looks to change that by ensuring that across our state, we're collecting the same information and that there's a centralized place where that information can be accessible to the public. Under the current system, part of the reason why we have such little information from our courts is also because of some interesting quirk in Illinois records laws that basically make it so that they're not subject to public disclosure in the way that other public institutions in the state are. So you can't FOIA the court to get this type of information. So under the PFA, this is what we're trying to gather to help us better understand what's happening from the point of arrest to the point of detention or release, and so we can actually hold our system accountable. And then finally, the Pretrial Fairness Act really does do a lot to make our community safer. It ensures that finances are no longer the determinant of freedom. It reduces incarceration, reduces crime, and strengthens communities. And then finally, reducing or eliminating money bail. There's been no study that's shown that reducing or eliminating money bail has caused an increase in crime or missed court dates. In fact, in 2017, in Cook County, there was an effort toward pretrial reform that predates this one. And in 2017, Chief Judge Evans issued General Order 18.8A. I'd encourage you to look it up if you have a chance. But there's plenty of evidence and research out there that really illustrates that after that order was introduced, that basically required judges to stop issuing such high unaffordable bonds because it was unconstitutional and was a massive issue. That order went into effect in 2017. Since then, there's been research that showed that between 2017 and 2020, there was no correlated increase in crime as a result of that, and that the individuals who were released as a result of being able to afford their money bonds were not found to have committed any new offenses as a result of their release. So I think it's important to really, drive that point home that it actually, makes communities safer. There's no evidence that it increases crime, and it gives communities a chance to avoid all the financial harm, the social harm, and devastation that can come with pretrial detention. And this really just kind of steps further. After Cook County doubled the number of people released pretrial without paying money, 99.4% of people successfully and safely returned to their communities. Between October 2017 and 2019, 98.7% of the people identified by Cook County's risk assessment tool as having a high risk of being arrested for a new violent offense were not charged with any new violent crimes while awaiting trial. Really important stuff. And then finally, how can folks get involved? How can people help? We'd love it if you would contact your local legislators. There's been a lot of misinformation going around about the Pretrial Fairness Act or about the Safety Act, and we have a tool to help you do that. I'll drop that in the chat in a second. I would encourage you to share that with your friends and families and encourage them to do the same. You can register to canvass in support of the Pretrial Fairness Act. You can also register to join us, the Illinois Network for Pretrial Justice, on November 16th to defend the Pretrial Fairness Act in Springfield. That's our lobby day. So we're really going to be working to try to, remind legislators of the importance of the Pretrial Fairness Act, to show our faces down there, because again, there are plenty of folks who want to undermine it, plenty of folks who, have tried to outright repeal it, or introduce amendments and changes that would really, really gut the bill. So we are, we're going to be there in force, and we would encourage, if you're interested, we would encourage you to join us. And then, of course, you can follow us on social media. We have a couple accounts that we'd encourage you to follow, and sign up for our newsletter to stay up to date on calls to action. And then, just in your own personal lives, just raise awareness of pretrial incarceration, the harms of pretrial incarceration, and money bond in your own networks. And then, finally, if there are other organizations or other activities that you guys might have going on, and you want us to come to you and really bring some knowledge about the Pretrial Fairness Act to the table, we're happy to do that. We have more individuals besides myself who have digested, a lot of this policy background, and we'd be happy to share it. And that would be it. So questions, I'm happy to stick around for a second to answer any questions, and maybe engage in a little discussion. I don't want to take up too much time though, in case you guys have, I'm sure you have more issues on the agenda to get to.
Well, thank you, Kareem, for that. I just got one quick question. So are they going to monitor the judges and make sure the judges are doing this correctly and not continuing to just deny everybody bail? Is there going to be consequences for judges who do that?
Well, there will be a lot of effort to make sure. So actually, as an example, right after the PFA goes into effect and money bond is no longer a means to detain someone. Again, the only way you can detain someone after January 1st of this coming year is if they are proven by the state to either represent a safety risk to another person, or if they represent a high likelihood of willful flight from the jurisdiction. If judges are for offenses that are not, let's say for very low level offenses, individuals are still, being jailed by judges. And the state's attorney is filing motions for detention for things that are very, very insignificant. The lawsuits would 100% be filed. There are organizations that are a part of our coalition who are standing by waiting for that. Right now, we're actually planning on doing some court watching efforts after the PFA goes into effect in 2023. Once that happens, what I mean by court watching is, we've done this before, but we're going to basically activate a lot of volunteers that we have. We're going to go into different jurisdictions around the state, sit in what was formerly bond court, which is now going to be, I guess you could call it conditions court, sit in there and just monitor, document what's happening. The public is allowed to go into bond court or conditions court at any time, even though there are certain jurisdictions where people will be, some courtroom actors might not receive us too well, might actually have tried to bar us. We're allowed to be there. We will be in there monitoring the implementation of the PFA and monitoring judicial behavior. But to answer your question directly, their lawsuits in those situations would and will be filed to make sure that the law is being implemented effectively as it should be.
Thank you. Anybody else have any questions?
I have a question. Where can we find that study that links that crime doesn't increase since this was put into effect?
Sorry, can you repeat that question one more time? I had just a little, can you say that one more time? I missed that.
You mentioned a study that mentions that that crime didn't increase.
Mm-hmm.
So where can we find that study?
Yeah, sure. So there's a study actually that was done by Loyola University of Chicago. that really looked at, the time period between that order, General Order 8A being introduced. And, it looked at, over the period of time that it was introduced, and between then and I believe 2019 or 2020, it looked for any changes or increases in crime among the individuals who were released. So I can share that study. It was, I think it's a really impactful study. I'll also be happy to share more information and materials about the harms of pretrial detention, and really how devastating it's been. There's a lot of research out there on the subject, so I'm happy to share some of that as well. And then Douglas, I think just so you know, I think I accidentally asked you to mute. That was my bad. That was not intentional. So I apologize for that. Listen, I'm not too good at being the host on Zoom.
No problem.
Anyone else have any questions or feedback?
And I can
No,
stop.
it was a great, very
I-
great
oh.
discussion.
Go ahead, we had somebody on mute.
I just say I enjoyed the whole presentation.
Yep,
Awesome.
very informative. Hopefully, everyone will take something away from this, and don't believe the hype. There is a lot of negative stuff going around about this. But people just got to understand, we got to protect our community. And this has been happening to us for way too long. We continue to be incarcerated for minor issues, and just because we can't afford to pay a bail, we're stuck in prison or stuck in jail, then wind up in prison. So thank you, Kareem. That was very informative.
Of course. Thank you guys for having me. I think I saw a couple of hands go up. I think in
William,
the chat
Shaw.
box.
Yes, I was wondering if you can elaborate more about the violent offenses for the Safety Act, because my mother-in-law, she's real concerned about if people committing violent offenses and how does that work for them. So if you can, go in more details with me with that so I can better explain it to her.
Sure.
Thank you.
So under the Pretrial Fairness Act, so again, once this goes into effect in January, any serious felony, serious crime is eligible for willful flight detention. So for example, if the state alleges based on the severity of the crime, when they file that motion for detention and submit that to the judge, if they allege that based on the severity of the offense, that there is a likelihood that this individual might flee the jurisdiction to evade prosecution, they can be detained under that standard. And then for the safety standard, which I had mentioned before, that would be available where there's a real possibility that safety is a risk. So for specific charges like first-degree murder, second-degree murder, armed robbery, pretty much all sex crimes, domestic violence, human trafficking, and a variety of gun crimes, individuals who, if the state alleges that there's a real risk to safety for those specific charges, if charges like that, individuals can be detained. So there's been a lot of misinformation circulating that has, suggested that basically on January 1st, everybody and anybody is just getting let out of jail, right? That is just, they're just unlocking the door. Everyone's flying out the courthouse. That is not what will happen. For one, everybody's going to have a court hearing. People aren't, the court system is really slow, right? For one, so people aren't. It's rarely the case that the justice system is eager to just let people go with no future contact, right? Now we're trying to change that, but it is going to be the case that while numbers do decrease for individuals who are incarcerated pretrial, for those specific more serious offenses that I just outlined, If the state is saying for an individual, for example, who's charged with armed robbery, that there's a serious risk to another individual's safety, then the state can, if the judge agrees, the state can detain that person in jail pre-trial. So if that answers your question.
Yes, it did. Thank you. Thank you.
Mm-hmm. Mm-hmm.
Will, I think you had raised your hand.
I primarily just wanted to say I appreciated the work that was done around this, Kareem, primarily because I have sat in courts before as well as visited people in jail. So there's a whole, and I'm actually from St. Louis. So this is actually looking at the system on a larger scale. And so it's the work that you just presented is showing me like some more of what I already know, but also at the same time, more specifics to what in regards to what I don't know. So I just wanted to say that this was very informative and I appreciate the work because yeah, I've been a part of programs that wanted me to get adapted to jail at the age of like 15 by showing me what a jail looked like in at the state capitol. So it's kind of like, I see the intricacies and I just wanted to say I appreciate the value of this work.
Hey, thank you for that. I really appreciate that, William. And you know, this is a national crisis. It's not an Illinois specific issue. There are certain states or certain cities that have done away with money bond or have tried to reform their pretrial system. But the Pretrial Fairness Act is by far the most progressive series of pretrial reforms across the country. And that's why we think it's so important that we protect that legislation. You know, it was, like I said, it was passed in 2021, but between 2021 and 2023, you know, we've given the state, the entire state, all of this time, you know, all these different counties, all this time to really get ready and implement and try to ready their pretrial systems so that we can implement the law effectively in January of next year. Unfortunately, you know, we have dealt with a number of bad faith actors, you know, conservatives, individuals in law enforcement who've been really trying to undermine, you know, the effectiveness of the law, trying to make sure that it does not go into effect and to maintain the status quo. And, you know, the jail system, the money bonds that they extract out of the jail system are also a source of revenue for a lot of counties around the state. So they have their incentives. But, you know, we have ours. We're trying to make sure that we can obviously, you know, save a lot of lives. And this is an act that we believe will save a lot of lives and really also preserve a lot of dignity. So I appreciate your comment and, you know, hopefully with supporters like you guys, we can, you know, get this thing implemented the right way.
Excellent, y'all. Well, we are past 7:30, so unless folks have any other feedback, we will give everybody back the rest of their Thursday night.
I have one thing to say. We do have a United Congregation of Metro East. We have a public meeting going on October 13th on Thursday from 6 p.m. to 8 p.m. You can register online. If you know anybody who want to go, they have transportation. There's gonna be food, raffles there. So, you know, put that out there for us, please.
Absolutely. Thanks for Anthony. If you can send that stuff, if you want to send stuff over email as well, we're happy to post it out on socials as well.
Is there a link for that event?
Yes, ma'am. I would have to. I'm working from my phone, so I see how I can get it posted up there to you. Or hold up. Give me a second. I can yeah, go. I'm sorry, y'all. Give me a second.